So the first conference was held in November 1995, and it came about because we had had first Dagenet in December 1994, and then Hill and Scientology in July of 95, as two really, really important cases that brought the Charter into the law of free expression.
The times were really ripe for such an organization because news outlets were really contesting some dispositions of the criminal code. They were really keen on developing jurisprudence that was favorable to freedom of the press.
Well, it was always important to IDEM, to me certainly, to have a website that could serve a number of functions. It would be a place where our members could keep up to date on the law. It would be a place where we could share developments in the law, what was good and what was bad about those developments, and to provide a focus for mobilizing ourselves and our clients to deal with the various challenges that we faced. And so in 1998, I reserved the name and set up the website and presented it to my colleagues. It has gradually built up over time, and I think it's fulfilled many of the objectives that we set for ourselves, and some others that we hadn't contemplated or hadn't focused on at the beginning, public education being one of them.
It was always important that it be a national organization. Right from the beginning, Dan Burnett, David Sutherland were there from the West Coast, and Jonathan Croft from the Middle, and of course many from Toronto and Montreal, and myself and David Coles and others from the East Coast. So it's always been national. And it's one of the interesting things from that point of view, and this is something that really goes back to the earlier days. We used to do, I think, a lot more in those days of talking around the circle and getting different views as to how some of us would treat different situations. And it was interesting to see how there were geographical divides across the country as to how some areas might deal with certain pre-publication issues one way and others might deal with them some other way.
Well, in the early days, post-charter, Alberta was a redneck jurisdiction, and I think judges really thought of the media as an annoyance, something that they had to put up with, and certainly it was very frequently an issue that provoked citations of contempt. So in that kind of redneck environment, we weren't welcomed in the courtroom in the early stages. In fact, I can remember a judge looking at me and asking, in the context of a fatality inquiry, what part of Get Out didn't I understand?
The openness of this organization to people from across Canada was apparent to me on the very first, at the very first conference that I attended. The folks were open. They communicated to me that the problems that I was struggling with in a small market were not that different than the problems that they were facing in larger markets. So I felt immediately part of the group. And I really hope that we've continued to be that welcoming for people who are younger and people from smaller markets as we've developed over the last 20 years.
It was actually the first or maybe second or third IDEM conference I was at ever. And that also coincided with the very beginning, years and years earlier, of the Rafe Mayer Wick Radio case that eventually went to the Supreme Court of Canada. So I'm at the conference, and the issue arose where somebody talked about how a plaintiff's lawyer in a defamation case tried to pull a maneuver where they would split the case and only put in part of their evidence and then leave the onus on the media defendants. And they got a ruling in that case. This is pre sort of internet having all the rulings available, that shouldn't happen. And that is exactly what happened in the first 10 minutes of the WIC radio trial. We were able to beat it back because of this piece of information that I had from the IDEM conference, and it's not exaggerating to say that it rippled through and may have affected the outcome of what is, many would say, the most important fair comment decision in our jurisprudence.
The conference is about sharing, and it's about sharing best practices, it's about sharing what goes on in other provinces, but also it's about sharing what goes on in the world. For CMLA and IDEM, it's an important part of our conference, and the perspective, the international perspective on these questions, on this fundamental principle of freedom of expression is key.
You know, presenting at IDEM has been such an honor for me and so much fun. It forces me to get myself up to speed on American media law developments so that I can communicate them to my friends north of the 49th parallel. It's a great opportunity for me to meet with them and find out what's going on in Canada. And not only occasionally, but many times, I found that things that are happening in Canada may drift south at the border. So it's a good early warning system for me.
Scots law is unusual because we have a mixed jurisdiction here, so it's neither a common law jurisdiction nor a civil law jurisdiction. I think the Canadian judiciary tend to have a kind of similar cultural mindset to the Scottish judiciary. So when we have the benefit of a Canadian Supreme Court decision like Crooks against Newton, we'll be waiting a long time for a hyperlinks decision in the Scottish jurisdiction, and certainly for one at that level. So I find Canadian decisions a very good straw in the wind for what the Scottish courts are likely to decide.
The clients saw this as a great opportunity to have all their outside lawyers and even inside lawyers have input, a common input as to how we would develop or try to develop the law of freedom of the press in Canada, what issues we wanted to advance the most, what were the best arguments in some instances to advance. We could coordinate all of that.
We've set a base for ourselves for advocacy on media law issues, and over time we've certainly made our mark. We've spoken to policy makers in governments across the country. We've spoken in front of judges across the country on media law issues. The organization is well known for the work it does. It's achieved changes in legislation, draft legislation, that have been to the benefit of free expression and free media.
I think our interventions have been really meaningful and have had a big impact on them in emphasizing the importance of the free expression cases they're hearing. And it also adds credibility to those of us who are there, that we're there on our own cases and we're there as interveners, so that we have the familiarity with the court and they're familiar with us to want to hear from us.
So WIC Radio was a case out of British Columbia that Dan Burnett had done and had succeeded at trial but lost on the Court of Appeal in BC, and it presented a very compelling fact situation and an opportunity to really get the court to grapple with this area of the law. In particular, let's start with the fact that the adjective fair should be dropped. Fair has no role in the protection of comment, I submit. It inevitably leads to misunderstanding and appears to call for the trier of fact to engage in an examination of the fairness of an expression of opinion. The Chief Justice has already referred to a quote in Reynolds by Lord Nichols, who has been a key developer of the law of defamation over the last decade, in which he points out that no longer should the word fair be used with comment. I think it should be called a defense of comment, because it does protect, clearly protect, is intended to protect exaggerated, obstinate, prejudiced opinion, even opinion expressed in gall.
I had the privilege to intervene in the Globe and Mail case at the Supreme Court on protection of sources for Daniel Leblanc. And that was, I think, a key judgment in Canada on protection of sources and therefore on investigative journalism.
Pour les intervenants que je représente, pour le journaliste que je représente, c'est un outil capital. Et regardez ce que M. le juge Laforêt dit dans l'essar, c'est à la page 430. Deuxième paragraphe. Selon moi, il ne fait guère de doute également que la collecte de l'information puisse dans beaucoup de cas être gravement entravée si le gouvernement a trop facilement accès aux renseignements qui sont à la possession des médias. Et regardez la prochaine phrase. Il me semble aller de soi que la possibilité que son identité soit révélée pourrait dissuader une personne de fournir des renseignements à un journaliste.
So I intervened in, I think, in 2 cases so far for the organization. One was the Criminal Lawyers Association case, and the other was the Information Commissioner case. So they're both access to information cases, and that's an area that has really interested me. And I think, again, it's an area where we've done quite a bit in working with our clients to promote the use of access legislation and to try to push the envelope on the law of that. They're both very frustrating cases in the end, and the Supreme Court, I think, needs to learn a lot more about access to information, because we've actually gone from being a leader in access to information in the 80s and early 90s to really being an outlier.
Good morning, Chief Justice, Justices. I appear on behalf of organizations that are among the largest users of access to information legislation in Canada, the media, and that includes most of Canada's daily newspapers. My clients use what I call right to information legislation daily in furtherance of the precise overarching purposes of the legislation that this court recognized in DAG and which bear repeating, namely to facilitate democracy by ensuring, first, that citizens have access to information necessary for them to participate meaningfully in the democratic process, and second, and again from the language of this court, that citizens can hold politicians and bureaucrats accountable for their actions, and I would add their inactions.
Over the years, I think the name IDEM at the Supreme Court of Canada has developed a real reputation for being helpful and being insightful, and the court, just from its reaction to interventions by IDEM, where it really tends to pay attention, has been quite gratifying. And so then it leads to the situation that arose in AB versus Bragg, where it was a publication ban issue on a difficult case involving a teenage girl who had been the victim of a fake Facebook profile.
The role of a judge applying the Dagenet-Mentuck test to any discretionary order sought to limit openness is to make the finding that there is a serious risk to the administration of justice. This discussion earlier about subjective versus objective, in my submission, a judge can look at both to arrive at that finding.
We've always had a very strong core or nucleus of people who have had this area as their principal practice, but I'd like to see us to continue to foster young lawyers who have an interest, who may not have quite as broad a media practice as other more senior members of our organization. I'd like to see us engage their interest more and encourage them to be on committees and the board itself. I'd like to see that process accelerate. I'd like to see us continue to play a leadership role on interventions. I'd like us to be forward-looking in terms of legislation on the horizon, developing positions and advancing them before we're stuck with laws that take us a step in the wrong direction.
Well, we have quite a handle in the name of the organization, which is IDEM/Canadian Media Lawyers Association. And as I said, when I was president, we had to formalize the organization, which required us to actually have a name to be registered. And Danny started the IDEM name at the beginning, and Bert Bruiser, in his wonderful way, each year when we had our annual meeting, would pipe up and say it was a crummy name and it should be the Canadian Media Lawyers Association. So some people liked IDEM, some people liked Canadian Media Lawyers Association. We had to make a decision, so I used the Great Canadian Compromise, and now we have both names, and I guess each of us can refer to the group as we wish.
The role of the Friday night dinner at the conference is I think, a great way to create those bonds and that friendship that I talked about previously. And it's not to be taken lightly. This generosity of lawyers sharing their knowledge, sharing that experience, is also based on friendship, and the Friday night dinner goes a long way to create those friendship.
I never want to miss the Friday night dinner because it is absolutely unique and it's always so much fun. The food's always excellent, the venue's always entertaining, and the company is the best in the world.
Happy 20th anniversary at IDEM.